Well, thanks everybody for joining us here. My name's Bill Kessler. I'm a lawyer at the firm of Beresford Booth, and I'm joined here by Andrew McKenzie, another attorney here at our firm. Andrew and I have been practicing in the area of real estate. It takes up a large amount of our practice. I since 2006, Andrew in California since when?
Since 2007, I've had my broker's license in California, and I've been practicing in the field of real estate in California since 2006.
And Andrew's also a managing real estate broker here in Washington, and as licensed as both, of course, as a lawyer and as a real estate broker since 2019. So we're presenting today about Form 17, the seller disclosure statement. And that is a document, just kind of to give an overview of, it's a document that every in at least in every residential transaction, the seller is obligated by default to give to the buyer. And I'm going to share my screen here. There it is. Okay, so that is that working, Andrew?
Yep.
Okay. So this is the first page of Form 17. The question is, what is it? This is a document you may have seen if you bought and sold real estate. And by the way, this presentation is for buyers, sellers, and real estate agents alike. We're going to try to have something that pertains to everybody here. But of course, you've seen this as a buyer or a seller if you've bought and sold real estate anytime in the last many years since this has been required. I'm not sure when it was first required, but it's been a long time. And so I'll kind of scroll around here. It is a total of 6 pages, and it's a whole bunch of yes, no, and I don't know questions that the seller is answering for the buyer. And so we'll go through that in a little more detail in a bit here. Andrew?
Yeah, so the format that we're doing generally to just make this a little easier is I'm going to be asking Bill some questions to kind of broach certain subject matters related to Form 17. Now, Form 17 is a departure from what the common law would have required in these kinds of situations. And there is a legal concept people have probably heard of called caveat emptor. Bill, do you want to explain what caveat emptor is?
Sure. So that is Latin for buyer beware, basically, and you always hear that term, and it gets chipped away. Buyer beware gets chipped away by the law here and there, but it is still the default for real estate in Washington. That it's on the buyer to be aware of what he or she is buying. So if there are defects, the default is that the risk is on the buyer of those defects being present upon closing. That being said, Form 17 takes a big chunk out of that. Andrew, did you want to add anything regarding caveat emptor?
Right. So caveat emptor is sort of still the law. It's sort of the default position that the law takes, and Form 17 should be sort of seen as not erasing caveat emptor, but just modifying it by also placing some responsibility on the sellers. Overall, Washington State is a very seller-friendly state when it comes to real estate transactions, but Form 17 can still be a form of or a source for liability for a seller for failing to disclose. So it's really important for sellers to take this very seriously. So Bill mentioned that the Form 17 is going to be required in the majority of these kinds of transactions, but is it possible for the parties to get around that requirement and waive the need for the seller to provide the Form 17?
So the answer to that is yes. The seller can get around disclosing all of these. Here, I'll just go through it. You'll see there's how many sections here. 10 separate sections with just a ton of questions to answer about the property. So yes, the seller gets around Form 17 by having the buyer affirmatively waive the right to receive the Form 17. The downside of doing that, of course, is it can harm the marketability of the property. It's common and it's the default to receive a Form 17. So if you as a seller are not giving a Form 17, then that potentially could be a red flag and harm the marketability of the property. But so there's certain circumstances in which you might when it might actually be a market thing to do and an acceptable normal thing to do not to give a Form 17. And that would be especially in the case of selling out of an estate when the seller is the person filling out the Form 17 is, say, the executor of an estate and is not familiar with the property, or is the attorney in fact under a power of attorney for the person selling, is a guardian of the person selling, the trustee of a trust, and when that trustee is not living there at the property. So you've got certain circumstances when it's perfectly acceptable to waive the Form 17. And you can, to be clear, you can as a seller can require the buyer to waive the Form 17. Or have that be a condition of sale. It's just, again, it can be not a market thing to do. So
now, one thing about the waiver of the Form 17, are there some of the provisions that the seller still is required to make disclosures about? For example, this environmental section.
Yes.
The statute that allows you to waive Form 17 does contain sort of a carve out that makes some of the disclosures non-waivable, correct?
Right, and there it is. And is my screen still sharing all right, Andrew?
Yes, it is.
Okay.
So we're looking at the Section 7 environmental here on the form.
Yep. So that Section 7, right? That's still non-waivable. And then let's see. Go ahead. And did you have anything else on that?
No. Well, I mean, just the point is, keep it on your radar screen that you can't just sit. You cannot get around this provision by contract. The statute still requires you to make these disclosures under Section 7.
Mm-hmm.
So, one of the things that I wanted to ask you about, Bill, in 2019, there was a change to some of the MLS forms that actually require by default, unless the parties agree otherwise, require that buyers who are doing their due diligence not provide information that they learn in their due diligence to the sellers in certain situations. Why would that change have been made, and what can you tell sellers about the dangers of learning too much?
Yes. Yeah, absolutely. So you, if you as the seller receive the buyer's inspection report or any other information that the buyer's diligence leads them to discover about the property, typically through the inspection, and then you as the seller give that information, or sorry, you as the buyer give that information to the seller, and then let's say the deal falls through. Now the seller's got information that he or she needs to disclose to the prospective new prospective new buyer in the Form 17, and so definitely not what a buyer or what a seller would want. So it gives the buyer some sort of strange power over the seller to be in this position of gathering information, then giving it, and then if things fall through, that he could then give that information to the to the seller, to force the seller to have to give it to a new buyer. So not a good situation. And so if now if a buyer were to give that inspection result to the seller without the request to do so by the seller, then that could be a breach of the purchase and sale. Again, certainly not what anyone would want on the buyer side. So it gives the seller a little bit of leverage. Andrew,
So
anything to
here's
add
a
there?
question, Bill. If you're a seller and you're trying to answer these questions on this Form 17, do you need to proactively go out and perform investigation in order to get the answers?
As the seller?
Yeah.
No, certainly not. It's just what your reasonable knowledge of the property, having either been there as a resident or as a landlord of the property. That, by the way, might be another circumstance in which you might try to get around the Form 17 disclosures if you're purely a landlord and it was purely an investment property, like an investment condo or single family home.
Right.
But no affirmative duty to investigate.
Right. So I think what we ought to do at this point is let's look at the Form 17. We certainly don't have time to go through every single question and sub question and all of that kind of stuff. But generally, when you go through the Form 17, you can see that the available answers in the right column, there's 4 different choices: yes, no, don't know, and not applicable. How should can you maybe pick out some examples on this form of areas or real life examples where you've seen issues come up in the way that sellers answer these questions?
Yeah. So let's do a quick overview of Form 17. So you start you start here by identifying the property and who the seller is up top, and then there's some instructions to the seller. You disclose whether you as a seller are occupying or not occupying the property, and then you've got categories of questions. You've got questions about the title of the property, questions about water in section 2 here, questions about sewer and septic in 3, then structural issues in 4, what they're calling systems and fixtures in 5, like wood stoves, fireplace inserts, electrical system, plumbing, that sort of thing. HOA interests, if there's an HOA, then 6 is applicable. 7's the big one we'll touch on, environmental. You got the good old lead-based paint question here, just as it is, and there's a separate lead-based paint disclosure in the MLS forms as well. Section 9, applicable only to manufactured and mobile homes, and my favorite is section 10, which will the full disclosure by seller. We'll go over that. So some examples here. We'll start under section 1. Do you have legal authority to sell the property? They're asking about easements. They're asking about assessments against the property. Query what that means, and that can mean different things in different circumstances, but just lowercase a assessments. Zoning violations, things like that. Water. Are you getting clean water all the time? Do you have a water treatment system like a softener for a well? Is irrigation water? So sewage questions, septic. Are you on public? Are you on septic? And some of these, and especially in section 3, that can be a little bit confusing. I've found you gotta pay close attention to that one. Structural, so talking about things like roof leaks, remodels. Have you had the roof leak? Do you have wood destroying organisms? You've got so systems and fixtures. Anyway, let's get to some of the some of the really interesting ones. And before we do that, I'll say that in general, the way that that Andrew and I have seen many sellers fill this out, oftentimes with the advice of their agent, is to take a firm position on yeses and nos. And very, very frequently, the answer should be, I don't know. And there are just many, many examples of this. The default answer should be, I don't know. Many people think they know the answer to these questions, but they really don't. So the obvious one, do you have legal authority to sell the property? That's a yes, but sort of from there you get to a lot of I don't knows. For example, is there a private road or easement agreement for access to the property? You say, well, I own this property outright. I'm not in an HOA. I don't have a private drive. Is there an easement agreement for access to the property? Well, might your water utility have an easement agreement for access to the property from 1943? Maybe, probably. Might the cable company have access, or the natural gas company? Probably. But are you sitting there at the time of answering this? Are you, the seller, sitting there looking at your title report? And even if you are looking at your title report, and I'm not being facetious, is that 100? Are you guaranteeing the accuracy of that title report? The answer is you don't know. You don't know if there's an easement. Now, if you are aware of one, you have a private road. You're positive that that you and your neighbors share a private driveway or something, then you know there's an easement. You just say yes, and you disclose that the existence of that easement. But if you think the answer is probably no, right here, if you think the answer is probably no, you would very likely stick with I don't know. And I use that as an example of what many of these questions are going to be. Here we are asking about the water system in 2A3. Are there any problems or repairs needed to the water system? Well, did you just go scope every single one of your pipes the minute before you answered this? No. So you're not aware of any problems or repairs, but this can be interpreted to essentially guarantee, at least there's an argument for the buyer, if you're wrong on this, that you've just guaranteed this water system. So are there any problems or repairs? You don't know that. Probably not, but that's another example of I don't know. So as we go down here, further, the I don't knows should generally continue until unless the answer is yes. So certainly, if there's anything to disclose, you want to be disclosing. And if anything, go ahead, Andrew.
Yeah, if you know about something, you just can't play dumb and say, I don't know. The goal
Right.
here is for you, the seller, to let the buyers know what you actually do know and what you actually don't know.
Yep.
So we got a question from one of our participants saying,
Oh,
I was
thanks.
looking at a home to purchase a few years back. It had a front porch, which is not listed in the description. We did not buy the home, but would something like that cause any problems? If yes, when and how? So if someone is, generally agents, when they're putting together an MLS listing, they're listing the features as a marketing tactic to show people what's included, to show them the value that they're getting. If it has a front porch, but it just wasn't listed in the MLS listing, I would not see that as a Form 17 problem. The goal of Form 17 is to alert buyers to material defects or potential material defects about the property that they should know about. The existence of a porch would probably not fall into that category. So hopefully that answers your question.
Yep. And so I'll skip down here to the environmental one. This is the biggest one on here, and it's one that I see the answer no the most, and where there is potentially the most liability. Well, there's liability throughout this thing potentially, but certainly in environmental. So again, there's no timeline associated with these questions. Has the property been used for commercial or industrial purposes? Well, not while you, the seller, have owned it. You might say no. But what's the timeline? What if it had before, a few years before? Is there any soil or groundwater contamination? There's huge soil contamination, groundwater contamination liability. Again, if you're saying no, there's the argument that you've just guaranteed. So you don't want, the answer is you don't know if you think the answer is no.
That's right. Some of these questions, really, there's almost never going to be a situation where the answer will be no, because with the questions having to do with reaching back into history with an unlimited time frame, there's no way that you could know as an owner of the property who only owned it for a finite period of time, how you could possibly know what happened before you ever got to it. Right. So the answers are almost always in these situations going to be don't know or yes, if you actually know of something.
Yeah. And then finally, good old number 10. Are there any other existing material defects affecting the property that a prospective buyer should know about? Basically, please, seller, please guarantee that everything's good to go other than what you disclosed up above. You definitely don't know the answer to that. That answer is not no. That is an I don't know. So that's a little flavor for Form 17. And Andrew, go ahead. Did you have anything to add here?
Right. So we've talked about caveat emptor, this buyer beware concept, and how Form 17 still imposes on sellers a duty. What are the ramifications of a seller not making the disclosures that would be required? You could talk about the Merger Doctrine, explain what that is, and what is the standard for deciding whether or not a seller is liable for failure to disclose?
Sure. So generally, a purchase and sale agreement, when you sign a purchase and sale agreement, buyer and seller sign, then they close, and the deed records. There's something called the Doctrine of Merger, which means that the purchase and sale agreement merges into the deed. So the buyer no longer has claims on the purchase and sale agreement, but only on the deed. And there are various deed warranties, and you've basically really shrunk the universe of claims that you've got against your seller. But the Form 17 is totally separate. It looks like it is an MLS form, and it kind of looks to the untrained eye, if you will, like part of the purchase and sale agreement, but it's not. It survives. So claims under the Form 17, of course, survive closing. Otherwise, it wouldn't really be worthwhile. So the typical example is a bunch of water damage behind the walls. It looks like it was painted over that the inspector didn't catch. Inspectors typically limit their liability to the price of the inspection. And so there's not a lot of recourse against your inspector as a buyer. But if it looks like it was a kind of a cover-up job, and there's a bunch of water damage behind the wall from leaked pipe, and you've got problems with the sheetrock, that kind of thing. That's kind of your garden variety Form 17 claim, and it's it's whether the seller knew. Is it knew or should have known, Andrew, or is it just an actual knowledge standard? I think it's an
actual knowledge standard here.
Yeah. So yeah, that to answer your question, that's
because as we were talking about before, sellers don't have an obligation to do investigation to figure out the answers to these questions.
Right.
They can answer the questions based upon what they know now.
Right.
So obviously you don't want to be deceptive in answering these questions. What would you tell brokers in terms of how they should approach the Form 17? What about the timing? When should you give the Form 17, and what are the ramifications of giving it late in the transaction?
Sure. Well, the first advice to brokers is that the Form 17 is just basically full of pitfalls, and it's full of liability for that seller. And there's kind of an art here. If you check a yes box, almost the vast majority of these yes boxes, if you check it, then you go down here below, and then you attach potentially many pages to this, and give a narrative description of why you checked yes. And doing that is kind of a dance between disclosing and not scaring off a buyer. You want them to know, but you don't want to scare them off. And intuitively, any broker knows that, and anyone knows that that's what they want to do. So that's something where we can be helpful in disclosing and helping advise, helping the broker and the broker's seller client fill this out. And
here's one other point to note about disclosures and the respective duties between buyer and seller. If a seller makes a misrepresentation in a disclosure form, the seller has exposure to liability, but liability is not guaranteed. And one of the reasons for that is, as I mentioned earlier on, Washington is still a very seller-friendly state, and that means that buyers still have an obligation to perform their own due diligence. And if the buyer knows of something that the seller didn't disclose, the buyer can't come in afterwards and say, oh, well, you're liable because you lied on this form or you didn't disclose this to me. Because the law is going to look to what the buyer knew, or what the buyer with a reasonable investigation, given their knowledge, should have discovered. So even though it's always wise to be forthcoming in these Form 17 disclosure statements, buyers should not assume that they have a slam dunk case every single time that a seller didn't disclose something.
Yeah, absolutely. And Andrew, you had also mentioned about the timing of when an agent should give the Form 17. I know a lot of agents will typically give it right at the beginning, and you had mentioned that it might even be possible to make the Form 17 a document that is actually an attachment to the MLS listing. I think that's right too. So give it early, because it's got a 3-day right of rescission for the essentially a right of cancellation rescission for the buyer from the time that he receives the Form 17.
Right, and one of the critical things about that is failure to give this disclosure statement can actually be a get out of jail free card for the buyer midway through the transaction, even if the buyer purported to make their earnest money deposit non-refundable. So you might, if you're a seller and you didn't give this disclosure statement, you are sitting exposed to the possibility that the transaction would be canceled and that you will not get anything. You won't get liquidated damages for the transaction falling through. The buyer can get their earnest money back if they cancel within the time frame allowed under this disclosure form. So that's one of the reasons why it's critical to give your disclosures as early as possible in the transaction, so you do not supply an additional ground for the buyer to get out of the transaction and get their earnest money back.
Yeah. And so one last message to agents would be that the statute allows the agent to fulfill the statutory duties of the agent on any issue where the agent is not certain to advise a client, whether a buyer or a seller, to seek the advice of real estate counsel. And we regularly deal with these forms and advising clients on how to fill them out. We litigate them on the back end, and so once you've litigated them, you tend to know them a little better, and the pitfalls that might be facing a seller given a specific set of facts. So that's all I've got. Andrew, anything else?
Just one thing, which is that we got another question from a participant asking.
Oh, thanks.
If this is part of the MLS, would you recommend to do a new Form 17 once you get serious about purchasing? Well, people being serious about purchasing is not the trigger that would trigger a new Form 17, but getting supplemental information could trigger a duty to provide an updated Form 17. So again, this is a disclosure by the seller. It's not a disclosure by the buyer. But so the point is, if you provided this Form 17 and then some new thing happens, some new material defect becomes known to you, or some answer on this form would change if the form were filled out today, then you have an obligation as the seller to provide an updated disclosure, or else you could be sitting on potential liability. So you gotta think of this as a continuing duty throughout the transaction.
Yep. I see we just got one last question here, and we'll run. How does a trustee of an estate handle this form? I recommend that a trustee, or trustee of a trust or an executor of an estate, I would recommend that they have the buyer waive the right to receive the Form 17. So you can do that as a separate Form 34 addendum, and just have some disclosure language in there. Alternatively, you can cross the whole thing out, and then hang on, I'll share my screen.
And that would leave you with just the obligation, assuming the buyer agrees, with making the environmental disclosures under Section 7. And in the overwhelming majority of cases, the answer to those questions is going to be, I don't know. So
Yep.
you will sidestep the majority of thorny issues,
Right.
that are raised in this Form 17.
Right. And so you'd require the buyer here as a seller in that case, to answer the question, you'd require the buyer to sign here the waiver of the right to receive the completed seller disclosure statement down at the bottom of the final page. All right, Andrew, anything else?
No, I think that's it.
Okay. Well, thank you everybody for joining us. Appreciate it. Questions, please feel free to call either Andrew or me directly. Anything we can do to help, we're glad to do it. Okay. Thank you all. Take care.
Thank you.